I'm feeling a bit like a talk show host with this stick in my hand right now. But I have the great pleasure of introducing Professor Novogrodsky, whom we're delighted to welcome to the Nathanson Center to Osgoode today to talk to us about judging stories, which is the title of the seminar that he's going to present. Noah Novogrodsky is a professor at the University of Wyoming Law School, where he teaches international human rights, immigration law, as well as civil procedure. He's a Phi Beta Kappa graduate with highest honors from Swarthmore College in the United States. He also holds a law degree from Yale Law School, as well as an MPhil in international relations from Cambridge University in the UK. After law school, he went on to clerked for the Honorable Nancy Gertner of the U.S. District Court for the District of Massachusetts. He was also Robert L. Bernstein Fellow in International Human Rights in Asmara, Eritrea, and Addis Ababa in Ethiopia, as well as Cape Town in South Africa. So our speaker today has been around. He was also a litigation associate, like any good law school graduate at the firm of Howard Rice and Nemirovsky, Kanadi, Falk, and Rabkin. My God, a very, very long, many partners there, yes, in San Francisco. And he was the founding director of the International Human Rights Clinic at the University of Toronto Faculty of Law. And in that capacity, he filed as an intervener a submission, a number of submissions, in fact, in the case of Immigration Canada versus Muga, Serra, a case which will be at the heart of his presentation today. He's also been a visiting professor at Georgetown Law School, and his scholarship, just to give you a little idea, focuses on issues of legal accountability for mass atrocities, the global HIV/AIDS pandemic, as well as the justiciability of social and economic rights. So today he's going to speak to us, as I said, about judging stories, and he's going to focus especially on the confluence of issues of incitement to genocide, as well as hate speech in a single case, the case of Muga, Serra, to explore the power of stories in law. And that power, he'll argue, defines how we see the world, how we form communities of meaning, and how we speak to one another. So without further ado, please join me in welcoming Professor Novogrodsky. I, unfortunately, as an associate dean, that's what associate deans do. I'm going to have to sneak out just in about half an hour. But deans gets to stay because I obviously have no work. But Amar Bhatia, who's a Catalyst Fellow here at Osgoode, has kindly agreed to take over me as host, and will manage the Q&A after a talk of about 30 minutes. Is that it? Okay. Thank you very much.
Thank you. Thank you all for having me to speak. And Dean Sasson, I really appreciate the opportunity to reflect on something that we were both involved in almost a decade ago. This presentation is about incitement to genocide, hate speech, and the Canadian Supreme Court case of Citizenship and Immigration Canada versus Leon Muga, Serra. On this subject, I have both a practical and a theoretical interest. I'm a professor at the University of Wyoming Law School, but before that, as the overly generous introduction alluded to, I was the director of the International Human Rights Clinic at U of T. And in that capacity, I supervised a team of students in work on an intervener submission in the aforementioned matter. The case concerned the immigration status of Leon Muga, Serra, a Rwandan immigrant to Canada who was deported back to Rwanda last year following a 17-year legal odyssey that included a bizarre anti-Semitic episode before the Supreme Court of Canada. My initial engagement with the case followed the path of most human rights lawyers, seeking to promote accountability and pushing the boundaries of international law. But as I reflect on the case after the passage of some time, I've come to see it as a story about stories, complete with profoundly novelistic qualities. The legal issues in this drama pivoted on language, the meaning of group insults, and the potential for courts and tribunals to assign consequences to speech. We are talking then in a very real sense about the law of stories and stories about law. The paper I have written is called Judging Stories, and it is animated by the two tales at the heart of this morality play. I have some paper copies of the piece, and I have electronic copies that I have given to the center. And so I welcome any edits, comments, suggestions, critiques, and I think I have about 8 weeks before it's going to be published to incorporate any suggestions. And I particularly welcome your comments on the Canadian content in the piece. So I'm a little out of touch with some of the Canadian practice here. And so if I have returned to that work inaccurately, I'm relying on you to help me get it right. So 2 stories. The first is the narrative told by Leon Muga in November 1992 at a time of heightened tensions between Hutu and Tutsi in Rwanda. Muga was the equivalent of a governor of a state in Rwanda, and he delivered an incendiary speech to a crowd of more than 1,000 supporters. And in that speech, he called Tutsis Inyenzis, which is Kinyarwanda for cockroaches, and he urged his followers to send the Inyenzis, quote, back to Ethiopia via the Nyabarongo River, a well-understood storytelling reference to the site of previous massacres of Tutsis in Rwanda. To be certain that his audience understood the message, Muga exhorted the crowd to take up arms. Quote, do not be afraid. Know that anyone whose neck you do not cut is the one who will cut your neck. Now, successive Canadian courts, relying on translations from the Kinyarwanda original, struggled to understand this anti-Tutsi polemic delivered in a foreign language and context. A few things are not in dispute. At the time of the speech, Muga was a recognized political leader. His speech fanned the flames and led to immediate violence, but not genocidal acts against Tutsis living in the area. In fact, the speech was so awful and broadcast so widely that a few weeks after the address, Muga was indicted by the courageous Attorney General of Rwanda, a Hutu gentleman, on charges of inciting violence. And I like to think that there was a police chief in the province of Gisenyi who opened a case against Muga, the Rwandan Bill Blair, if you will. I was figuring out how to figure out if I could get a Rob Ford joke into this presentation, but
you're much further along than I would have been.
yeah. Well, he's not yet at the level of inciting genocide, but you know, it's mind-boggling to people who don't live here. Yeah. To people who live here, yeah. Muga fled to Spain, and from there he lawfully emigrated to Canada with his family in 1993, a year before the worst violence erupted in Rwanda. After the genocide, Muga was discovered living in Quebec by Tutsi refugees who had fled to Canada. Muga was teaching, what else, linguistics at Laval University. If anyone knows the power of language, it is he. In 1995, Canadian officials began an attempt to deport Muga and his family on the ground that he was a possible war criminal and therefore was ineligible to have entered Canada in the first place. The Canadian Immigration Court studied the speech and ultimately ordered Muga deported. This decision was narrowed but upheld by Justice Nedan, the most recent Canadian Supreme Court appointee. Almost the most recent?
He's appointed, he's just not working anymore.
Yeah, okay. This was the holding of the Immigration Appeal Division, which spent an unprecedented 27 days on a single immigration case. If any of you have ever worked in the immigration system is known for fast-track rough justice. If you get a half a day in front of an immigration adjudicator, that's a lot, right? The Immigration Appeal Division in Quebec called 21 witnesses, spent 27 days, and ultimately found that Muga Serra had incited genocide and was therefore responsible for a crime against humanity and had accordingly misrepresented. He checked a box on his immigration to Canada that said, I am not a war criminal. And this was a rather ridiculous part of the Immigration Appeal Division's decision, in my opinion, because he had not been convicted of being a war criminal. In fact, he had given a political speech, and I think the misrepresentation part of the lower court's decision was a red herring here, right? But it gave him grounds to appeal, and that he did. And so he appeals to the federal court, which dispatches of the misrepresentation allegation, but upholds the deportation order as to the crime against humanity. He then appeals to the Federal Court of Appeal. And that court, a 3-judge panel, all Quebecois judges, rules that the lower court decision was patently unreasonable. It holds that if the lower courts had accepted a different translation, they would have seen that Muga Serra was simply calling on his political supporters to resist foreign invaders and act in self-defense. And somewhat shockingly, the Federal Court of Appeal revisits the translation of the word inyenzi, cockroach, and finds that this inflammatory phrase that was at the heart of hate radio and the genocidal propaganda in Rwanda doesn't mean cockroach, it means outsider or foreigner. And in so doing, it vacates the deportation order and allows Leon Muga Serra to remain in the country. The Federal Court of Appeal decision held that, quote, the speaker, Muga Serra, was a fervent supporter of democracy. The themes of his speeches were elections, courage, and, get this, love. Even though it is true that some of his statements were misplaced or unfortunate, there is nothing in the evidence to indicate that Mr. Muga Serra was guilty of a crime. Take a look at the last line of the concurrence by Justice Letourneau. He cites the now immortal words of Hughes Means in the Psychode and says, quote, as I was going up the stairs, I met a man who wasn't there. And then the opinion ends. This is the last word of the Federal Court of Appeal decision. I'm not making this up. I mean, it's translated from the original French, but it's rather remarkable that the Federal Court of Appeal basically said that these words were not inflammatory and that we had our eyes on the wrong guy. Right? The Government of Canada appealed to the Supreme Court, which elected to hear the case. And over the summer of 2004, I sought leave to intervene on behalf of the U of T Clinic in partnership with Human Rights Watch and the Canadian Jewish Congress, which has a long-standing interest in war crimes prosecutions and in the potential deportation of Nazi war criminals in Canada. We argued, as a group of 3 interveners, that the legal standard of incitement had been well developed by the International Criminal Tribunal for Rwanda in a case involving the hate radio station RTML. I will spare you the full brief, but factum, sorry, that was my American coming out. And this is the table of contents. And for those of you familiar with human rights argument, this is decidedly unexceptional. What we're really saying is that there's an international tribunal that has defined incitement to genocide, and the Canadian Supreme Court may want to educate itself as to that standard and consider applying it in this case. The second story in this whole sordid matter unfolded 3 weeks before the Supreme Court hearing. Muga Serra's counsel, his name is Guy Bertrand, filed an abuse of process motion with the Canadian Supreme Court based on 2 claims. Bertrand alleged an abuse of power by the then Minister of Citizenship and Immigration, as well as an abuse of power by Erwin Cotler, the former Minister of Justice. Bertrand asserted that, quote, strongly influenced by Jewish individuals and organizations, the government had elected to appeal the Federal Court of Appeals decision and have the Muga Serra family deported at all costs, end quote. Bertrand also insisted that there was an apprehension of bias on the part of the Supreme Court as a whole. Bertrand claimed that Rosie Abella's presence on the court, a judge born in a displaced persons camp and whose spouse, Irving Abella, who I believe is associated with this university and is the former chair of the Canadian Jewish Congress, would impair the ability of the balance of the court's members to remain impartial. This is an appendix to a filing that Guy Bertrand submitted in the case. And I don't know if you can, you don't need to be a French speaker to understand what he's getting at here. He argues that there is a system that he calls justice parallèle. And the parallel justice system here is a collection of human rights advocates, lawyers, and government officials who he claims are seeking to deport Guy Bertrand and family, pictured in the family portrait in the upper left-hand corner, to Rwanda, where they will face torture and death, right? So expulsion equals torture and death, right? And this is the claim made by Guy Bertrand in his submission, and it shocked almost everybody involved in the case, including some outside observers, and I think I might put Dean Sossin in that category. Nobody knew this was coming. Guy Bertrand is an interesting figure, at least for an academic to study. He has been both a sovereigntist, a federalist. He is a regular flamboyant lawyer in Supreme Court matters, and he took on this case. But up to this moment, nobody knew that he was prone to making an argument alleging a Jewish conspiracy at the Canadian Supreme Court that many observers would view as outright anti-Semitic. Okay. The government of Canada filed an anodyne response in which it denied the existence of a broad Jewish conspiracy and said, no, there is no system of parallel justice. I threw up a little bit in my mouth when I read this government response because it failed to call out Bertrand's motion for what it was, which was this outrageous anti-Semitic submission. So in the face of these claims, we as interveners did an unprecedented thing. We filed a reply. And the Supreme Court let us do it. And we said in our, I'm sorry, let me stop to say that at this moment, this was big news. So the Globe and Mail, the National Post, others opined on the fact that Guy Bertrand had made this motion. And the Globe and Mail called the charges against Erwin Cotler absurd. The National Post described Bertrand's theory as pernicious. We responded and suggested that the court really should not accept a submission or the argument on abuse of process that was founded in something that constituted a kind of stylized hate speech. Right? And Bertrand then responded to our reply, which I think technically is a surreply, and filed a response that said, no, this is not anti-Semitism. This is an actual conspiracy. And how do we know that it's an actual conspiracy? Because Justice Abella is a self-professed member of the Jew-judiciary. Now we thought we were in some Kafkaesque world where you don't have to be postmodern to realize that if you file the initial claim, you're going to be branded an anti-Semite. And his response was, this has nothing to do with anti-Semitism. It has everything to do with a self-declared conspiracy from a member of the Jew-judiciary. Right? Okay. The Supreme Court scheduled a hearing on the abuse of process motion to be heard before the merits of the case. So two stories, Leon Mugesera's initial anti-Tutsi rant and Guy Bertrand, or in a sense, Leon Mugesera's submission to the Supreme Court of Canada, two stories that created very different outcomes and different procedures. The first story is so vile that it led to mass killing. And in fact, there is some evidence that a recording of the speech was played repeatedly on RTML radio at the height of the genocide. The seriousness of this story is reflected in what ultimately became a 121-page decision of the Canadian Supreme Court. And the result of that decision could not have been more consequential for Leon Mugesera, who, if he is to be believed, was on trial for his life. The second story also got a Supreme Court hearing, but it was met with confusion rather than historic meaning. Bertrand's abuse of process motion recycled the old canard that the Jew is a plotting outsider intent on using governmental power for nefarious purposes. And consciously or not, Bertrand's charge that a Jewish cabal intended to send the respondents' children to certain torture and death contained more than a hint of the infamous blood libel, the false and enduring charge that Jews use the blood of Christians in religious ritual. But that story is largely devoid of meaning in present-day Canadian society, since the audience for that message is generally not primed or prepared to receive it. So unlike Mugesera's speech, which enjoyed abiding significance in the historic Tutsi-Hutu enmity, Bertrand's story had no moral to share, no enabling context, even as he offered a protagonist and an invented collection of antagonists. My claim is that absent ethos, logos, or pathos, Bertrand's abuse of process motion confounded the justices because it failed to follow the outlines of a salient script. So the Supreme Court let Guy Bertrand make this motion for 15 minutes. It then took a recess. It did not allow the government or any interveners to respond. It came back from the recess, said the motion is denied, reasons to follow, and then it scheduled a hearing. Then it proceeded with the hearing on the merits of the case. So rather than suppressing Bertrand's odious speech, the court exposed it to sunlight. The court ultimately denied the motion and named it for what it was. But my inquiry started with the wildly disparate treatment of these two stories. Right? One story creates cataclysmic consequences in Rwanda. The other story produces a collective shrug and some confusion in the Canadian environment. Right? And so the paper that I have written offers a theory of why it is that some stories matter and others do not. And I start with a claim that many societies are governed by what I call master stories. Master stories are the collective narratives that we use and police in law to produce a relevant context for the state in question. Master stories are the product of founding bargains, such as in Canada. They are inscribed in law, either by judges or more commonly by legislatures, and they are tested over time. So they have a heuristic quality, that is to say that you don't just announce that there's a new master story in a society and expect everybody in the community to abide by it. Right? In Rwanda, everybody knows what the master story is. The story there is about the longstanding tensions between the colonial invested group, the Tutsis, who are an ethnic minority in Rwanda, and the group that had been summarily excluded from power by colonial authorities, the Belgians and Germans before them, the Hutu. In the democratic post-colonial era, Hutus took their revenge on Tutsis. And with numerical superiority, they created a state that was actively hostile to the Tutsi minority. I think if we do some comparative work, we can see that many states have different master stories. Right? So we know what the master story is in South Africa. It is the story of apartheid and racial differentiation. South Africa's enormous and laudable constitution mentions the equality guarantee 126 times in the constitution. If you don't know what the master story is in South Africa, you've been living under a rock, right? 13 European countries subject to Nazi occupation now outlaw, they have prohibited in law the crime of Holocaust denialism. So if you utter that the Holocaust didn't happen, you can be criminally prosecuted in 13 countries in Europe, right? And in Canada, what's the master story? It has to be the division between French and English Canada, between Catholic and Protestant, and between civil law and common law traditions. Right? How do we know this? Because the first 7 articles of the Charter refer to this founding bargain. And I think there are many other stories in Canada that deserve to be told. The story of Aboriginal rights, the story of other minority groups, but they do not receive the same kind of treatment in the Canadian Charter. That reflects the power at the time of negotiation, and I don't know if you're still teaching this seminar, Dean Sossin, but we have experts in the room who can tell you who had a voice in 1982, right? Which is to say that I think that Leon Muga Serra gave a speech that operated on the fault lines of Rwanda's master story. Guy Bertrand, who had previously opined on issues of sovereignty for Quebec on Canada's fault line, was here delivering an anti-Semitic series of arguments that fell on deaf ears. Right? And so that brings me to the second part of my claim here, which is that judges play a unique role in constructing master stories. Judges are ultimately readers of text and sometimes of context. And in this situation, the Canadian Supreme Court was tasked with opining on something that it was wholly foreign to its experience as a collective, which was the Hutu-Tutsi division in Rwanda, and whether Leon Mugesera's speech had in fact been a catalyst for genocide. And then it was dealing with an allegation of a conspiracy involving its own members, right, which might have been painful, but was certainly not Canada's master story. And as Supreme Courts are wont to do, it issued two opinions. And so judges are writers of stories too, and the judicial opinion is a unique text. And the claim I make in the paper, and which I think is borne out in this story, is that the Canadian Supreme Court is contributing to a transnational narrative on incitement to genocide. It does so by carefully parsing the text and validating certain stories and certain contextual signposts in order to determine that Leon Mugesera did in fact incite genocide and would therefore be deportable on that basis, right? 6 months after the hearing at the Supreme Court, the court found that Mugesera was more likely than not responsible for incitement to genocide, and that he had therefore committed a crime against humanity. And it holds that, quote, in the face of unspeakable tragedies, the community of nations must provide a unified response. Crimes against humanity falls within this category. The interpretation and application of Canadian provisions regarding crimes against humanity must therefore accord with international law. Our nation's deeply held commitment to individual dignity, freedom, and fundamental rights requires nothing less. It's interesting. Here, the court arrogates to itself the responsibility to declare an international crime, and it references our own posture vis-a-vis international law as suggestive of the influence that allows the court to make a contribution in this area by defining Mugesera's speech as a crime against humanity. On the abuse of process motion, the court held, although it is not our usual practice, the content of the motion and of its allegations compels us to point out that it is unprofessional and unacceptable. It constitutes an unqualified and abusive attack on the integrity of the judges of this court. In an attempt to establish the alleged Jewish conspiracy and abuse of process against the Mugeseras, the pleading systematically referred to irresponsible innuendo. The only abuse of process from this motion lies at the feet of the respondent, Mugesera, and Mr. Bertrand. And then it adds, regretfully, we must also mention that the motion and the documents filed in support of it include anti-Semitic sentiment and views that most have thought had disappeared from Canadian society. So with that, the court reprimanded Bertrand, but applied no sanction for his particular form of hate speech. The case was referred to the Barreau of Quebec for a letter of reproach, but there was no disciplinary action taken. Let me be perfectly clear about this. Had Guy Bertrand put a client's retainer check in the wrong account, he would have been punished more severely than he was in this case. Right? There is no discretion for that accounting misdeed, whereas there is no consequence for this kind of Supreme Court attack or assault, save for the written opinion. And in that, I think there is something to the notion that judges are creators of text and story in ways that can matter across time and space. I think there were a couple of outcomes. In conclusion, I want to identify those outcomes and invite questions and comments on the thesis of this presentation. Scholars engaged with international law questions have considered what constitutes incitement to genocide, and the jurisprudential development of Canada's Crimes Against Humanity standard, and to a lesser extent the ethical issues of Bertrand's conduct, represent a written denouement or conclusion to this case that might be useful to other courts and tribunals considering similar questions. We might think of the anti-Semitism here as an unfortunate side note to the central theme, but I think there's a connection that's worth exploring, and it has to do with the power of story. Lately, I've been thinking a lot about stories and storytelling. For the parents in the room here, you will know that your children, if they're like my children, ask you to repeat the same stories over and over again. My 10-year-old daughter has committed many stories to memory. She is a performer, and she cares about accent, diction, pronunciation, narrative structure. If I do not tell her a story with the exact same cadence or characters, or if I, heaven forbid, forget what I said when I was so exhausted and reading to her the night before, she corrects me instantly. It's becoming obvious to me that stories matter. There's a burgeoning interdisciplinary literature on the emancipatory power of stories, as if every story is an act of resistance, a slave narrative passed down from generation to generation that communicates a special message, the Da Vinci Code for academics. Right? But having lived through this story, it's plain to me that stories can be a destructive force as well, that words have enduring power, that in some circumstances, the utterance can and should be criminal. So in conclusion, I believe there are three takeaways from the two Muga-Serra decisions. Number one is that we can and should be able to judge speech. It's not easy, but it's not impossible. Muga-Serra raises the question of whether a person may be deported or extradited for speech alone. Using translation, experts, witnesses, and recordings, we can distinguish between the ravings of a blogger and the threat posed by a political figure capable of implementing a genocidal plan. International tribunals have begun to define incitement and have clarified that there are some categories of speech-based offenses that qualify as international crimes. Here it seems to me that courts are searching for a universal standard and have begun to coalesce around the idea that exterminationist rhetoric is particularly dangerous when it is uttered by someone who has the capacity to implement that plan. Right? And that the dignity-based rights of affected parties can counterbalance or offset the expressive interests of the speaker. The global and instant reach of communication, coupled with the fact that public statements are now memorialized forever, makes getting this right all the more important. We should all want a global standard that works to stop the genocide, but rejects, for example, the fatwa issued against Salman Rushdie. Second, context matters. Muga-Serra's speech from a public authority in a time of reciprocal massacres constituted a real and present danger. Bertrand's accusations were more bizarre than destabilizing. So there is a difference between wresting control of a Kigali radio station and a 2-minute diatribe on City TV's Speaker's Corner. Right? As Azar Nafizi's provocative title, Reading Lolita in Tehran, demonstrates, geography can render some narratives taboo. The trick is to encourage the free flow of ideas while monitoring the incessant messaging that can convert a volatile situation into actual violence. And my third and final point is that it is wholly appropriate that courts are now in the game. The early conversations about incitement to genocide in Rwanda focused on the UN's failure to shut down the radio stations. Now we have a reasoned judicial voice beginning to articulate the boundaries of incitement. This, after all, is what courts do best. Courts are sometimes called the least dangerous branch of government for a reason. All they really have is words. And the effort of the Canadian Supreme Court in the two Muga Serra decisions appears to me to be a conscious attempt to supplant hate speech with the authority of legal language. Law derives its power from language, and the Muga Serra case reminds us that there is no greater authority than the power to say the law, jurisdiction. Law, I want to suggest, is inextricably embedded in narrative. And I think that we all benefit from recognizing how hate propaganda can be displaced by law at its best. That is, through the delivery of a new story imbued with meaning and influence. Thank you.
So, if I can begin
Yeah.
on the first question, just because it comes up so much in this. Yeah, let me make sure. Now the question's got to make sense if it's going to be captured.
Right.
If I go behind.
Well, it'll be memorialized forever, right?
Well, you gotta watch out for that.
Right.
So here's the kind of received wisdom around this issue, and I've never seen the data underlying it, but I know you'll be more familiar with it, which is came up in lots of hate speech litigation over the years, and that's that the propagation of some of the Nazi viewpoints was enhanced when there were attempts by the legal establishment of the day to go after those propagating anti-Semitic messages and gave an amplifying and legitimating quality to that. Now, it's serious enough to be, just part of the to and fro in a court case, plus widely covered in the way that Kirk Makin's piece, if you, don't cover litigation issues in the Supreme Court, this would have died an obscure death, but suddenly became headline news. So what about that storytelling? In other words, what do we do when we elevate, in a sense, kind of a crackpot position by someone who would otherwise not attract any attention, but for what we now are characterizing as a narrative or a storytelling that seems equivalent morally and otherwise, if you're a new and fresh eyes observer, to other narratives that might be ongoing and competing at the same time?
Right. Well, it's a great question, and I think I have a three-part answer to it, and I hope that it's satisfactory. But the first answer is that it's really a question of journalistic ethics and of the responsibility of journalists to cover newsworthy stories. And I have very little opinion about where you draw the line between sort of a crazy, individual speaker and drawing attention and giving, as you say, an amplified voice to somebody who might be a marginal political figure, but is going to grow in stature because of the coverage, right?
The speaker may have elected municipal office, let's
say. Right.
What have you.
Yes, and so, in a sense, there is a whole body of scholarship on the ethics of coverage and what it means to give pride of place or prominence to crackpot theories. Right? My second answer is that this is becoming less of a problem, which is to say that we don't inhabit a world in which a few publications occupy the whole landscape, right? And so I think the internet is a great leveler, and the fact that you have hateful material and certain blog sites is part of this sort of cacophony of noise, and I think we have democratized, and we have less of a problem with a single radio station disseminating a consistent vile message any longer, right? My third point is that when that happens, we have now defined incitement to genocide as inextricably linked to the collapse of the marketplace of ideas. And so I think what you really want to be worried about, and Susan Benesch and some other scholars have done this, is focusing on the crowding out effect of alternative voices, right? So for example, in 2007 in Kenya, there was pronounced ethnic violence, and that violence is now being adjudicated by the International Criminal Court. Right? But on the ground in Kenya in 2007, apparently the way the crowds were mobilized to attack different ethnic and neighborhood groups was by blast text messaging. And there's a lot of new technology to try to interrupt blast texting in some contexts without infringing the individual rights of a speaker to communicate with one person or 5 people, but not 5,000 people. Right?
Couldn't that just be the resistance in, kind of Egypt as well? Like, how do you know if you're restricting it that it's not for tyranny as opposed to
Right.
repress, kind of extremism?
I think those are very fair concerns and considerations, but I fall on this question of the bigger question of promoting more speech rather than restricting it because it can be used for nefarious ends. I fall pretty far on the spectrum of free speech, right? And I'm curious to know whether incitement to genocide will continue to be defined in narrow and applicable ways. And my related concern would be using these examples from Nazi Germany and from Rwanda of hate speech being elevated to incitement to genocide as a pretext for authoritarian regimes to claim that, put differently, I think it means something very different when a leader in Kenya uses the bully pulpit to call on his followers to attack an ethnic group, as opposed to, a mean-spirited, embittered blogger wanting to have his say, or and frankly, I think there are differences even between speech and incitement in ways that can and should be policed. Right?
Any other questions? You can collect some or go one by one.
Thanks for that talk, first of all. It was totally fascinating, and it kind of brought me back to that time and my kind of quick peripheral reading of the case at the time. But my question is related to the master story thesis that you put forward, and the question of how that dovetails with kind of national myth making and the extent to which these master stories are either true or kind of based on an idealized version of what might be the truth or something that's not true at all.
Right.
And so that's my first question, actually, is just to kind of ask you about how you see these two kind of national myths and master stories coexisting. But more specifically on the case, I'd be interested to hear your thoughts about the fact that Canada decided to respond to Mr. Muga Serra's presence here, not by way of prosecution, but by way of trying to rid ourselves of him, which is a consistent pattern in our war crimes legislation is so rarely used, mostly because of the fact that we actually prefer to let other people do it and not go forward with prosecutions. And so that kind of gets back to the myth-making storytelling issue. When you think about the language in the Supreme Court's decision about our commitment to international prosecutions, about our commitment to the embedding of international criminal law within the domestic context. Right. And so then the question is that just kind of more myth-making, and what we actually wanted was nothing to do with this guy, or does it represent something else?
Okay. Two very good questions. The first question is normally framed a little differently, and I want to sort of reposition it, if I might, so that the question of what is a master story here and how that differs from national myths, I think is important because there can be multiple stories in any given society, and which ones do we want to credit as master stories, and which ones are the important narratives that bind subgroups together but might not be called a national story, right? And the late Robert Cover obviously was all over this with Nomos and narrative, but he was focused on groups that reject a national narrative as constitutive of their membership in the broader society, right? So religious groups or political outsiders who tell stories, often about resistance and struggle, that are markers of their identity in that group, right? And I think these stories are critically important, but they're not master stories if they don't have the power of law behind them. And so I'm using codification in law as a distinguishing feature between the many myths that circulate in society and those that have that are enforceable either because by courts or perhaps by institutions in a legislative framework. And so, for example, I think it is critical, let's use the United States as an example, that race is obviously a master story. We know this because the 13th Amendment to the United States Constitution, and even the original Constitution, was so focused on racial identification. Now, does this mean that women's rights or LGBT rights or other stories are insignificant? No, but it doesn't. It means that they are not a national story policed in the same fashion. And so my three-part claim for what makes a master story is that it is first and foremost applicable to the country as a whole and not to a sub-region. Second, that it is reflected in law. And third, that it is tested over time. I thought it was fascinating when President Obama said recently, when he came out in favor of gay rights, he put Stonewall, Selma, and Seneca Falls together as a triad, right? And he's doing so in language, but law hasn't yet caught up to that. So I think he has a unique opportunity to begin to talk about marginalized groups receiving mainstream attention and absorption into the national narrative. But to the extent that we have different tiers of scrutiny for constitutional review in the United States, some focused on race as opposed to sex, gender, or sexual orientation, I think that there is a difference in law, and that difference is reflected, and I spend some time in the article, and I would welcome your thoughts on that. For example, I think that Aboriginal voices should be heard differently in Canada, and if you look at the Charter, you see some evidence for that, but not nearly as much as the founding bargain that brought French and English together in Confederation in this country. Right? A second question here, and I think it's a very good one, is why did we seek to deport rather than prosecute Muga Serra? At the time of the deportation proceedings, we did not have an extradition treaty with Rwanda, and so we could not extradite him. Remember, he had been criminally indicted in Rwanda, and so that would have been the cleanest way of ensuring that someone who committed a criminal act in another country would be prosecuted in that country for the crime. But I really think it's the standard of review here that dictated the case. I mean, we had a hard time marshaling enough evidence to deport him. So I don't think you were going to get a situation like the Munyaneza case where there was a full-blown prosecution under the Crimes Against Humanity Act against Leon Muga Serra. Deportation was hard enough, right? And I think you raise a good point, which is that we as a society have internalized many of our international legal commitments, and it's a little bit rich or maybe hypocritical to say that we want somebody else to prosecute, but we're not going to carry the laboring oar ourselves, right? I think there is something, I have done some work as an international prosecutor, and there is something to the fact that witnesses and evidence are in another country. And it is a kind of judicial imperialism to sweep in cases that have more relevance for another place, right? The reason this case took 17 years to reach its conclusion is that Rwanda still had the death penalty. And so until Rwanda abolished the death penalty, we wouldn't deport Muga Serra, even though he was found to be deportable, right? This story gets more and more bizarre as it goes on. So Leon Muga Serra was ultimately flown to Rwanda, not before some last-minute appeals and attempts to invoke Canada's commitments under the ICCPR and other international treaties to prevent his deportation.
And that was still by Bertrand, right? I think he's
Yeah.
their lawyer.
Not on the Human Rights Committee complaint, but yeah, he was. All of the attempted stays were by Bertrand. Finally, Muga Serra is deported to Rwanda. And in his first appearance in a Rwandan court, he claimed that proceedings against him in Kinyarwanda were prejudicial and that he wanted him to be in French, and that he didn't understand Kinyarwanda. This is the lingua franca of his 1992 notorious speech, right? So I think there are a lot of intersections here between law and language, and Muga Serra is the story that keeps giving in interesting ways. Yeah.
Here with the mic. Hi, thanks, Professor. My question relates to, I guess, your questions about why counsel for Muga Serra wasn't disciplined beyond the judgment itself, and I'm guessing that it might be dealing with, again, the question from the first person here was that you don't want to give necessarily a bully pulpit to someone who could say, oh, well, I'm going to appeal my discipline from the the barreau in Quebec. Right. I don't want the court may have been just uncomfortable about like getting those people out of the woodworks about you're infringing on his free speech. If counsel can't advocate zealously for his client, then what? So I'm wondering if your colleagues or yourselves thought about, again, that tension that the Supreme Court is dealing with about, sanction versus, again, like letting them kind of air their laundry like with Keekstra.
Right.
Thanks.
Right. That's a great question. I think that there's an uncomfortable reality at work here, and here's what it is. If Guy Bertrand had written an op-ed in which he claimed that the Canadian Supreme Court was subject to a Jewish conspiracy, he could have been prosecuted or civilly held accountable. And you could imagine libel, slander, defamation being civil remedies, and you could also imagine some criminal prosecutions if it posed a kind of danger in violation of the Canadian Criminal Code, right? He gets immunity for anything he writes in a legal submission. And this is absolutely right. We do not want to chill even outrageous speech in legal proceedings. And so, because the remedy there is that you lose the case, which is what he did, right? But if we ever had a situation where the Supreme Court seemed to be in the grasp of some kind of conspiracy, I would want a courageous lawyer to challenge that under something like the abuse of process standard, right? And so I think what the Canadian Supreme Court was dealing with was a kind of immunized speech here because it occurred in legal proceedings. And I think that's right under the canons of legal ethics and professional responsibility. And then we switch to the question of whether the coverage of his crazy theory is itself a violation of journalistic integrity or ethics. But I think what the court was informed by this basic understanding that anything goes in legal proceedings, right? Now the Barreau can or should have examined the totality of this case, and I have no idea what happens in Quebec legal disciplinary proceedings. All I know is that the case was referred to the Barreau, and that ultimately Guy Bertrand wrote a letter of apology, and this might be in order to maintain his standing with the Barreau. But there was no formal legal sanction, right? And then Guy Bertrand went on to challenge the Stanley Cup and whether the NHL should be the custodian of the cup, which was another case that he took to the Supreme Court. And he's also been agitating.
Where does that fit into the master story?
Right, yeah. It's the only story that matters sometimes a year, right? I think that another issue that has been near and dear to Guy Bertrand's heart is whether Quebecois players should have their own team in the Hockey World Cup or in the Olympics. And so this is, that's cutting closer to our master story, right? If you're going to sort of hive off Quebecers for national team purposes, I think you would be operating on the fault lanes of society, and English Canada would have no goaltenders, right? So there would be some other problems there, right?
Any other questions? Actually, I had, just to take the, while I'm here, so there's something about the master story thing. It's, I just wanted to know, in terms of the new master story that you say is being forged maybe transnationally by the courts, is that story one that's sort of being rolled out in each country, or is that something that's at the scale of the international?
I think it's happening more at the international level than on a state-by-state basis. I think it's appropriate for individual judiciaries and lawmakers in states to grapple with their own difficult past and their legal framework that helps to codify certain stories as more important or defended against criticism in ways that other stories are not, right? But on the international plane, I think there is now a concerted effort to try to define what is incitement to genocide and what would constitute an international criminal offense, as opposed to the many forms of hate speech that we hear every day in more and more media, right? Much of this has focused on what I think is a misguided effort to refer the case of Ahmadinejad from Iran's former leader to the International Criminal Court for prosecution on the basis that he has denied the Holocaust, or he denied it publicly at times, and he appears to have been part of calling for global jihad against Israel and Jewish individuals, right? So Irwin Cotler and Bill Graham and some other Canadian officials did draft an indictment and send it to the ICC trying to accuse Ahmadinejad of inciting genocide. The prosecutor did nothing with this request for prosecution. And I think in a legal academy, it's worth peeling this back and thinking, why is it that Muga Serra's speech was so dangerous, and why is Ahmadinejad's speech perhaps less dangerous, right? There is something at the core of this that doesn't make sense, which is that incitement to genocide is an inchoate offense. That means that no genocide actually has to happen for it to be charged, because the crime is in the utterance, right? So if one communicates the message, according to the Genocide Convention, which is named the Convention on the Prevention and Punishment of Genocide, it can be sanctioned or interdicted before any genocide ever happens, right? In practice, no one is ever going to charge someone with incitement to genocide that doesn't occur. And that's more of the case of Ahmadinejad. And I think we want to be extremely careful and narrowly draw the boundaries of this understanding of an international crime. And I think that process is happening both at international tribunals and at the high courts of, like the Canadian Supreme Court, that have time and attention to give to this important issue.
There's no other questions. Just wanted to thank you.
Thank you for having me.
And
I appreciate it.
Nathan Center, we have a mug.
Oh, great. I have a Nathanson mug.
Yeah.
Thank you very much. There's a paper here, and I welcome your comments on it.
Thank you.
All right, thank you.